Hello everyone, my name is Nekme Obasoge. Today's topic is deeply rooted in the Bini native law and custom regarding the inheritance of the igog. The igog is the ancestral house of the Bini family. Under the Bini native law and custom, the eldest son of the family has the right to inherit the igog, depend on the structure of the family. The Bini people also practice what we call uhure. Uhure is like a tutelary in English. It's used to worship the spirit of the ancestors. And the uhure is given to the eldest son of the family. Some of the male children in the family can also apply for the uhure, depend on the structure of the family. So these are some of the traditions that the Europeans misinterpreted about the Bini people during the early contact. So why are we here today? A few days ago, Chief Arala of Bini, Lawal Osula, joined his ancestors. Was it not May 15, 2022? He was a very talented and prominent musician in Bini, and his legacy continued to live on. However, before he died, there was a controversial court case between himself, his father's wife, and the 4 girls of the father's wife. Before his father died in 1972, he wrote a will. In the will, he didn't mention his eldest son and all the children he had before he married to the last wife. And he divided his most expensive properties to his last wife and the 4 girls that the last wife had for him. The eldest son of the family was excluded from inheriting the most expensive property of his deceased father. Definitely, this type of exclusion will exacerbate tension and controversy among the children. So the children that were not mentioned in the will took this case to court, and the case went to the Supreme Court of Nigeria. Without applying the Bini native law and custom, the court ruled in favor of the will, saying that the properties of Chief Lawal Osula should be given to the wife and the 4 girls according to how it was written in the will. This court case has become one of the most notable court cases taught around the world. So today's analysis focuses on how the rule of law and the will written by Chief Lawal Osula contradicted the Bini native law and custom, because the eldest son of the family has the right to inherit the superior igog, or the most expensive property of his deceased father, under the Bini native law and custom. In the case of Chief Arala of Bini, Lawal Osula, that just joined his ancestors a few days ago, he lived all his life without inheriting the most expensive property of his deceased father. First of all, Chief Arala of Bini belongs to the Oba family, and the title is hereditary in accordance to the law of primogeniture. The same law of primogeniture applies to the Bini native law and custom of igog. So today's topic is very interesting. Chief Lawal Osula joined his ancestors in Bini City on December 2nd, 1972, the day after he returned from hospital in England. At the time of his death, he was survived by his wife, Lindia Lawal Osula, and his 4 daughters. Chief Lawal Osula was an international art collector and sponsored the 3rd floor of the Bini City National Museum. In 1965, Chief Lawal Osula appealed through Sir Francis Conmee Bruce to the British people during a party honoring the chief in Lagos to let them have back in Bini some of the treasures which were looted during the Bini expedition of 1897. He was also instrumental in getting Vice Admiral Sir Gilbert Stevenson to return a Bini ceremonial sacrificial sword acquired during the Bini expedition to the Oba of Bini through his son Gilbert L. Stevenson Jr. Chief Lawal Osula was a Nigerian businessman with interest across insurance, real estate, and other industries. As a member of the Bini royal family, he held a hereditary traditional title as the Arala of Bini at the time of his death. Again, I will reiterate, the title Arala of Bini is a hereditary title. Chief Arala that just joined his ancestors a few days ago is called Lawal Osula, while the father is called Chief Lawal Osula. So the Arala that just joined his ancestors a few days ago was the eldest son of Chief Lawal Osula. So before Chief Usman Lawal Osula joined his ancestors in 1972, he wrote a will. In the will, he didn't mention his eldest son and all the children he had before he married to the last wife. Given that the provisions entrenched in the Bini native law and custom give the eldest son of the family to inherit the chieftaincy title, the same right applies to the inheritance of Igogbe. Therefore, Chief Lawal Osula was given the right to inherit the chieftaincy title, the Arala of Benin. He was also granted the right to inherit the Igogbe, where the father resided all his life. The court case of the will of Chief Usman Lawal Osula has become one of the most notable family law cases taught around the world, as final judgment came after 23 years of dispute and court battles. At the time of his death in 1972, a will was written by him dated November 22, 1968. By the Benin native law and custom, a Benin traditional chief is succeeded by his eldest son at death. But before the death of Chief Usman Lawal Osula, he made a will in which he made provisions for his wife and children. The eldest son and the rest children, who were not mentioned in the will, instituted a court case against the wife of Chief Usman Lawal Osula and his 4 daughters. In 1986, the complainants initiated an action in which they claimed against the defendants that the last testament of the testator, dated November 22, 1968, is null and void in the Benin State High Court. Despite the chief stating in the will that nobody shall modify or vary this will, it is my will that the native law and custom of Benin shall not apply to alter or modify this my will. However, in 1995, 2 years after the death of the first defendant, Mrs. Linda Lawal Osula, the Supreme Court of Nigeria made a ruling that the real estate and personal properties comprised in the estate of Chief Usman Lawal Osula be handed over to his wife and children as stated in the will. In the event whereby the deceased father denied the right of the eldest son of the family from inheriting the Igogbe or the superior Igogbe, controversy like this is inevitable in the family. There is a case going on in Benin as we are speaking. Before the man died, he wrote a will and excluded the eldest son of the family from inheriting the Igogbe because he believed that the eldest son has a kind of unusual behavior. Therefore, he excluded him from inheriting the Igogbe. Since this man died, the word peace is a myth in the family. Knowing fully well that the right of the eldest son of the family to inherit the Igogbe is deeply rooted in the Benin native law and custom, even though that child is an Ibesa. What the court is referring to as the superior and inferior Igogbe. In Benin, some of the Igogbe properties are dilapidated houses. They have been there for centuries. In the case whereby the deceased father was very wealthy and accumulated more expensive properties or built a more expensive house outside of the regular Igogbe, such expensive house will be considered as the superior Igogbe, while the regular Igogbe, probably the dilapidated Igogbe, will be reduced to inferior Igogbe. If the eldest son of the family is confined with the inferior Igogbe, he will assume that his right to inherit the most expensive property or the superior Igogbe of his deceased father has been compromised because the eldest son of the family believes that he is entitled to inherit the most expensive property of his deceased father. In some Benin men who had preference for some of their children other than the eldest son have in the process of time turned around the laid down customary law of inheritance just to satisfy their ego. By so doing, contributing to the escalating controversies surrounding the succession to the Igogbe. These were the controversies contained in the case of Lawal Osula versus Lawal Osula in 1995. In that case, Chief Usman Lawal Osula made a will on how his properties would be shared among his children and wife. In it, he divided his Igogbe to another child of his while his eldest son was still alive. You can see why this case was very controversial. The court unanimously held that Igogbe cannot be taken away from the eldest son who succeeds him to the title or office. The factor enumerated above contributed to the confusion surrounding the succession to the Igogbe in the Bini native law and custom. Nevertheless, these controversies regarding succession to the Igogbe over the years appears to have received a ray of hope of settlement. This is as a result of the resolution of the Oba of Bini and his council of chiefs, who are the ultimate custodian of the Bini native law and custom. This case also went to the palace of the Oba of Benin during the reign of Oba Hereditary. Now, let's look at how the Oba applied the Benin native law and custom to solve this puzzle. The custom says that it is the eldest son that automatically inherits the Igogbe of his deceased father, while the remaining landed properties, if any, are shared among the remaining children. But there have been cases where the Igogbe property is by far inferior to the other landed property or properties, usually because the late man chose to live in the inferior house while he put the superior house out for commercial purpose. The eldest son in such a case would feel cheated to be confined to the inferior Igogbe, while his juniors are given the superior landed properties. On a strict interpretation of custom, that is how it should be. But in these days of modern development, it would be unfair to give the eldest son a dilapidated property simply because it is the Igogbe, and give a more superior one that the deceased and marked for commercial purpose to a junior. Such cases have come to the palace, and the Omonoba Hereditary, in consultation with chiefs in attendance, has exercised his traditional discretion by giving the eldest son the option to choose between the inferior Igogbe property and the other superior property, on the condition that if he chooses the other superior property, he will fulfill his traditional right to the inferior Igogbe property, with all that goes with it. The eldest son had accepted the choice, and it has been endorsed by the palace. This is very complicated. According to this article, the Oba of Benin always give the eldest son of the family the option to choose between the inferior and the superior Igogbe. In the case whereby the eldest son decided to choose the superior Igogbe, then he will have to fulfill his traditional right embedded in the inferior Igogbe. In the case of Chief Lawal Osula, the musician that just joined his ancestors, he was bestowed with the chieftaincy title because the title is hereditary, and the father did not mention the inferior Igogbe in his will, so he was given the right to inherit the inferior Igogbe. The eldest son of the family believes that he is entitled to inherit the most expensive property of his deceased father. The practice of the alien double or multiple Igogbe, which is a strong factor escalating the contention that is causing division among siblings of the same man. It should be noted that the courts of Nigeria have a copy of the Omonoba Herediary's preposition to modify the ancient strict customary law of succession of the Igogbe. In other words, ignorance of the law is not an excuse to any form of misconduct. The idea of Oba Hereditary to modify the strict customary law rule of Igogbe succession is a welcome intervention to help solve and eradicate the contention surrounding the mystery of succession to the Igogbe in the Benin Kingdom. It will also help to bring a lasting solution to eradicate the perpetration of double or multiple Igogbe that is destroying the peace and harmony of the Benin people's and family structure. Unlike in the ancient times when our ancestors were not accumulating too much properties, one single igog can be passed down from one generation to another for centuries with little or no controversy like this. But in modern day Benin Kingdom, the family structure is gradually changing dimensions, and the Benin native law and custom should be modified to accommodate the changing structure of the Bini families. This can help to mitigate controversies like this among siblings whenever their parents join their ancestors. Now, let's look at who exactly can inherit the igog. The popular trend at that time was the eldest son supposed to take the superior house or the most expensive property of his deceased father. In addition, take possession of his father's supposed inferior igog. Most of the reason gathered for this deviation reckons that the inferior igog carries the symbol of his late father, thus enabling him to perform his fatherly role more efficiently in the quest of the ancestral worship. The eldest son was expected to take both the most expensive property of the deceased father and the inferior igog. The idea was that Chief Lawal Osula, the musician that just died, will inherit the inferior igog where the father resided all his life, because the inferior igog carries the symbol of his late father and the ancestral home of the family. In addition, he was expected to inherit at least some of the expensive properties of his deceased father. But before the father died, he willed his most expensive properties to the last wife and the 4 girls that the last wife had for him. According to the analysis of the court case, it was only the last wife that was legally married to the chief, while the mothers of the rest children he had before he married to the last wife were not properly married to Chief Lawal Osula. Even the mother of the eldest son was not properly married to the chief. Probably the last wife contributed to the development of his properties, or the last wife was a part of the success story of the chief. That was the reason he decided to will the most expensive properties to the last wife and the 4 girls that the last wife had for him. Because this case is unusual in the Benin Kingdom. There is a popular notion in Benin that a female does not carry the name of the family. She is to marry and move to her husband's house. We have seen so many cases whereby the eldest son of the family will dominate all the properties of the deceased father, while he will not allow the rest children to have at least a glimpse of the properties. In the case of Chief Lawal Osula, the younger girls were given the lion's share. Due to the significance of the igog, the Benin native law and custom has set down guidelines and perimeters to be followed or fulfilled when it comes to succession to the igog. In the first place, it is only the biological child of the deceased that has a right of inheritance. It is only where the man does not have any biological child of his own that the right of inheritance can go to a brother or a close member of the family who has blood ties with the deceased. The Benin native law and custom forbids an adopted child who has no blood relationship with the deceased from inheriting the igog. Therefore, to inherit the igog, the adopted child must be an offspring within that particular family unit. This is because the igog is regarded as an ancestral family house. This buttresses the saying in Bini, Oriobe Erioba Wedo, which means a stranger cannot become an Oba in the Benin Kingdom. It should be clarified that an adopted child can be given a farmland or any personal property of the deceased, but not the igog. The Wiz law cannot negate this customary rule. In Benin, it is forbidden for an adopted child that does not belong to that particular family unit to inherit the igog. Under the Benin native law and custom, a stranger cannot usurp the inheritance of the igog. It is forbidden. The right of inheriting the igog is given absolutely to the eldest surviving son of the deceased. It does not matter whether the child is responsible, an imbecile, or a usurper. This implies that a Benin man cannot give out his igog during his lifetime to any other child, because the principal dwelling house becomes an igog after death. So it cannot be given out as a gift, whether through the instrumentality of a will or by way of a declaration by the deceased. It should be noted that where a Bini man denies paternity is supposedly a surviving son, the customary law of succession has provided a means or accepting that eldest son supposedly denied paternity after the death of his father. The first condition is that the mother of such alleged eldest surviving son of the deceased, if she is still alive, is expected to swear an oath of confirmation at the ancestral shrine of the man, to the extent that the child is sincerely the biological child of the late father. Also, the mother of the child must follow it up with a traditional rite of what the Bini termed ikenwu. This literally means a ritual of cooking in a mud-built cooker at the kitchen of the deceased man for members of the man's family. When this customary rites of oath-taking and ikenwu have been performed by the mother of the eldest child supposedly denied paternity, the child will be accepted by the head of the family as the deceased man's biological child. Going by the provision of customary law above, it should be in order to say that a proper marriage under the Benin native law and custom between the Benin man and the mother of the eldest son is a prerequisite for the acquisition of the igog. Thus, when a woman's dowry has been paid, she must thereafter cohabit with the man. In the course of the marriage, she observed the customary law of ikenwu and oath-taking to the knowledge of every member of that particular family. It should also be noted in matters of this nature that a subsequent marriage under the Act cannot deprive the eldest surviving son his right to inherit the igog, even when the mother is not properly married to the deceased man, provided there is a credible evidence to buttress the claim of paternity. If there is a doubt of evidence in favor of the child, the issue of paternity will be resolved in the interest of the supposedly rejected child, especially when he is well known by the extended family members. This was the issue provoked by the case of Lawal Osula versus Lawal Osula in 1995. The Benin native law and custom stipulates that whenever the supposedly eldest son of the family is denied paternity, the mother of that child is expected to swear an oath of confirmation at the ancestral shrine of the man or the deceased man located at the igog. That's why the igog is very important in the Benin native law and custom. After performing and completing all the traditional rites, the child is accepted into the family and the child is granted the right to inherit the igog. Even though the mother is not properly married to the father, that does not limit the rights of the child from inheriting the igog. That is the tradition. In the Benin Kingdom, there is another tradition called ikenwu. When the mother of the child is not properly married to the father, the mother is expected to perform a traditional rite called ikenwu. After completing the rite, the child is fully accepted into the family. The same thing applies to when a child is denied paternity. The mother of the child is mandated to swear an oath at the ancestral shrine. In Benin, we call it Emiowa, meaning the spirit of the ancestors. The mother is mandated to swear the spirit of the ancestors to confirm truly and sincerely that the child is the biological child of the Benin man. It is only a faithful mother that will swear the spirit of the ancestors. The Benin women understand the nitty-gritty and the intricacies of swearing the spirit of the ancestors. In the case of Chief Arala of Benin that just joined his ancestors few days ago, the musician, the mother was not properly married to the father. However, that does not impede his right from inheriting the igog or the superior igog, depend on how people evaluate it under the Benin native law and custom. Majority of the eldest sons of the families believe that they are entitled to inherit the most expensive properties of their deceased fathers. Whenever any eldest son of the family is denied the right to inherit the most expensive property or the superior igog of the deceased father, controversies like this, court cases, disputes over inheritance of the deceased father become the order of the day. Today, the father's wife and some of the children who were involved in the court cases, disputes, and controversies over the properties of Chief Usman Lawal Osula have died. No matter how much we try to accumulate wealth in this world, no matter how much we try to fight for properties, one thing for sure, death is inevitable. Nobody goes to heaven with property. So we have the moral obligation to make this world a better place to live. That is the end of my presentation today. Thank you all for watching, and bye for now.